Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
My great pleasure to welcome back Professor Mario Barnes, Constitutional Law Professor from UCI's School of Law. With his wide experience covering many areas of jurisprudence from race, gender, education, to military law, Dr. Barnes brings a special breadth and depth to assist us in understanding how the courts and our judicial system works. This skill is essentially critical in this time of unnerving, even dangerous Supreme Court decisions. Please welcome Mr. Mario Barnes. Thank you.
So first of all, it is always a pleasure to be among the concerned citizens of Laguna Woods Village. Thank you, Barbara. It's always a chuckle because you don't know how hard Barbara works because she always books me a year in advance. She checks in at 6 months, 5 months, 4 months, 3 months, 3 weeks ago, 5 days ago. Always saying, look, we're just really, excited to have you. We just want to make sure. And I told her, barring severe illness or injury, I would be in the building because one of the things it means to work at a great public university is to make the resource of the university available to the greater community. So you can't always come to us. You can't sit in on our classes or attend all UCI events. But it's wonderful to be able to come and share time and space with you and talk about something so important as one of the three sort of critical pieces, or we normally say three branches, but the court is not really a branch, three pieces of our constitutional democracy. So let's talk about it. Let me see. Okay, so tonight, what I hope to get through fairly quickly so we can leave time for questions is to run through first a run through of some of the important cases we had from the last term of the United States Supreme Court. Some of you may have been at UCI the first week of July where myself, former Dean Erwin Chemerinsky, Stanford professor Jennifer Chacon, and some of our other colleagues discussed these cases. So I'll give you a little bit of the sort of, for each opinion, the majority of sort of the important rule the court came to, but also some interesting tidbit either from a concurrence or some kind of factoid to help place it in context. Then it's important when we talk about the court that we not forget to talk about the court as an institution. So part of what we'll discuss at least a bit is to ask, where we are this year and what was the uproar last year over the perceived lack of judicial ethics on the court. We'll talk about whether, in fact, we see any shifting judicial sort of philosophies and alliances among the court. And then finally, I want to talk to you about something that has become, for me, an issue over the last 3 terms of the court, which is this question about whether our current court is exhibiting a lack of respect for stare decisis, which is a lack of respect for precedent or earlier decisions of the court. And then I've picked 4 cases from the new term to talk about a little bit, to give you a preview of probably what I'll be standing here talking about next year at this time in terms of what has passed in the court. So let's start talking about what went on in this term. It's interesting, I looked, and last year I started last year talking to you about a case that was coming in South Carolina, Alexander versus the NAACP of the state of South Carolina, which was a case about racial and or political gerrymandering. We'll talk a little bit about U.S. versus Rahimi, which is a case about what is the extent of our protections under the Second Amendment. We'll talk about Loper-Bright, which won't mean anything to most of you as average citizens because we don't think about ourselves in relation to government agencies, but turns out to be an incredibly important decision, both in terms of the expanse of the power of the court, but how work gets done in a democracy where we rely on the administrative state to do that work. And then we'll finish up by talking about one of the post-Dobbs abortion cases, last year's mifepristone case, FDA versus Alliance for Hippocratic Medicine. A case that, for reasons of coming from a working class family where we lived in around, many struggling people, some who from time to time became unhoused, became important for me to watch, which was City of Grants Pass versus Johnson. It was about what do we do in a society when people have no place to sleep, but the cities want to regulate them off of public streets and highways. And then finally, probably none of you have heard about this case, Trump versus US, has something to do with presidents, immunity, crime, I don't know, something along those lines, but we'll talk about it. Again, we'll talk about that, three sort of elements of the evolving Roberts Court, and then we'll talk a little bit about cases that are already granted cert for this next term. So let's talk about Alexander versus NAACP. So I came here last year almost a little tongue-in-cheek and said to you, so this is a case where what has happened is the Republican Party for the state, who has the duty for redistricting because they hold the majority in the state houses, has redrawn districts in a way in which there was a claim of racial gerrymandering, where they moved 200,000 voters, mostly African American, to prevent from having to make sort of two what we would think of as majority black districts. They would have been heavily Democratic districts, but they were sued based on the notion of moving those folks involved racial gerrymandering. And their answer, I said tongue-in-cheek last year, was, well, we didn't move them because they were black, we moved them because they were Democrats. And I said, well, that's an interesting answer. I'm not racially gerrymandering, I'm merely politically gerrymandering. And the question is, well, how can you tell the difference when the overwhelming number of African Americans in South Carolina are actually Democrat? And that's what we were actually going to have to ask the court to figure out. And so the district court in South Carolina actually took witnesses, heard evidence, and it said, look, it's true that you wanted a Republican majority in District 1, but the way you got there was relying on race. And so we might think that what the Supreme Court would have said was, yeah, you cannot use race in that way. And what the Supreme Court actually said is, well, who was using race? According to the Supreme Court, you can only make a claim that there's racial gerrymandering, and here's the wording, where race is the predominant factor motivating the legislature's decision to place a significant number of voters within or without a particular district, to which many of you will say, well, isn't that what happened? And the court said, no, that's not what happened. At least we don't have compelling evidence that that's what happened. And what they claimed is where you have this correlation between race and partisanship, a constitutionally permissible partisan gerrymandered map can look very similar to an unlawfully racially gerrymandered map. In the verbiage of the 1970s, I hope some of you were around then, I will give you what we would say then, say what? Which is simply to say, that doesn't make much sense, but that was what the majority said, and it was a 6-3 majority along what we might think of as conservative to more liberal lines. But Justice Kagan in dissent, and if I had written this dissent, these are the very things I would have leaned on. She says, the challengers introduced more than enough evidence of racial gerrymandering to support the district court's judgment. The majority's attempt to explain its contrary result fails at every turn. The majority picks and chooses evidence of its liking, ignores or minimizes less convenient proof, disdains the panel's judgments about witness credibility, and makes a series of mistakes about expert opinions. In other words, they sort of, according to Justice Kagan, they kind of cherry-picked the record in such a way that, so all they needed to be able to say, according to the majority, is, yes, it could have been about race, but if it could also be about politics, then we cannot make the determination that race was the predominant reason for that. Now, just so you know, we have a census, we do it every 4 years. The reason we do it is because population metrics change. And in South Carolina, the population metrics changed such that there was a greater proportion of African Americans, such that in the way they were located, they should have constituted 2 voting districts. But what happens ultimately, they kept 1 voting district by moving some out. And the whole point is, if that is the way you achieve it, should we have to ask about your underlying motivation? Because the court seems to suggest it's the underlying motivation that matters. This is another example of our court not doing a great job with what to do with race and correlation. So one of the most famous or infamous cases in Supreme Court history is a case called McCleskey versus Kemp from 1987. It was a case involving the death penalty in Georgia. A very famous scientist, Baldus, did a series of studies where he looked at if you control for the types of crimes, if you control for he controlled for 238 variables that you can look at in and around a murder conviction. And he said if you control them or use multiple regression, so you hold them constant to see how much each variable is associated with an outcome, if you control the variables, what you will see, what matters the most to who gets sentenced to death in Georgia for murder is the race of the victim and the race of the perpetrator. And if you were a black person who killed a white person, you were many, many times more likely to be sentenced to death. Many people thought that might lead the court to invalidate the death penalty as operating in an arbitrary and capricious manner. But what actually happened is Justice Powell famously said, well, what you have is proof of a correlation between race and the death penalty and not causation. If you cannot prove that the state of Georgia chose its current system because of the impact race was creating on the result, then you cannot make a constitutional claim. To me, this, which is still good law, is deeply problematic, but also shows the kind of problems we can have when we don't think in more sophisticated or complicated ways about what to do with associations. It seems to me that if what you have is a race of individuals strongly associated with a political party, then you have to say when people do things related on partisanship that they're also capturing a racial element, right? At least it seems that you should be willing to presumptively explore that rather than make people come up with proof metrics that are going to be difficult to prove. But that is where we came down. It's a partisan decision. We had a number of these 6-3 decisions, which are essentially Justice Kagan Sotomayor and Justice Jackson in dissent. Okay, so Rahimi is a case where I actually was pretty worried about this case. It might turn out to be in some ways a bit of a surprise for the term, because what you have is a 8-1 decision in and around Second Amendment rights. And so essentially this question was, can you have a federal statute that places a reasonable limitation on gun possession for an individual who is a threat to physically harm others? And the facts of this case were pretty egregious in terms of the individual and the evidence that was presented on the fact. But there really was a question about whether we could actually regulate the Second Amendment in this way, mostly because two recent cases, right? Most recently, the Bruen case from New York and the McDonald case from Chicago suggested that, led by Justice Alito and Justice Thomas on this question, that the court had crafted a nearly sacrosanct devotion to the coverage of the Second Amendment, meaning there was almost going to be no state regulation to which they would be friendly. But in a surprise in that it was 8-1, Justice Thomas did in fact dissent, but in an 8-1 decision, the court said it does not violate the Second Amendment to create, hear me now, a reasonable limit on the Second Amendment for someone who might use a gun in a way that would be a threat or danger to others. There is a federal statute, so I spent 23 years in the Navy on active duty and in the reserve, and we had something in the federal government then called the Laufenberg Amendment, which basically said even for military members, if you were someone who was convicted of a domestic violence offense, you were not allowed to have a firearm, even if it was something that was assigned to you for your military duties. And so if you are willing to uphold that in the context of the military, it seems to me we should be able to uphold it within the context of civilian society. So it was a bit of a surprise in that we see that there is some reasonable regulation that is allowed at the fringes of the Second Amendment. Now, Justice Thomas, leaning on what he often does, history and framers' intent, says, there is no historical regulation that justifies limiting even a dangerous person's access to their weapon. And one of his typical fellow travelers, Justice Kavanaugh, in concurrence somewhat disagrees. So he lists off all the ways in histories we have allowed for limited, meaningful regulation of even the Second Amendment. The funny thing is, he goes from the historical point to ask the question whether the court, in fact, should be balancing the weight of interest between the individual right and the societal right. And I have to tell you, with a bit of personal attachment, what he said about that. So here's what he said about whether we should balance rights in this context. He says, whatever you think about it, this approach balancing is essentially policy by another name. It requires judges to weigh the benefits against the burdens of a law and to uphold the law as constitutional. In the judge's view, if the law is sufficiently reasonable and important. And I thought to myself, that's so eloquently worded. And then I realized he was quoting me. Actually, to be fair, he was quoting me and Erwin Chemerinsky, who wrote this article years ago about how we should understand strict scrutiny. But I love it, because don't ever run to your mother talking about, I just got quoted in the Supreme Court, until you read the next paragraph. He quoted us just to vehemently disagree with us. So he says of this balancing, he says, to begin, as I explained, this kind of balancing approach to constitutional interpretation departs from what framers such as Madison stated, what jurists such as Marshall and Scalia did, what judges as umpires, that's his thing, judges as umpires should strive to do, and what this court has actually done across the constitutional landscape for the last 2 centuries. And I thought to myself, well, if your only, sight in a Supreme Court case is to have someone disagreeing with you, I still take it. So, and by the way, we're right, he's wrong. Nah. Just so you know. But, and all we're arguing about is, in fact, what should we use to determine when we infringe on people's rights? We have to put something in a balance, right? We already know the cost to the individual of not being able to have their gun. But when what is on the other side is violence toward other people, why wouldn't you encourage there to be some judicious, efficient use of balancing? He says that's not how we do it, but he, in fact, did the thing we were suggesting should happen, which is that there should be a reasonable limit or encroachment. Okay, so as I suggested, this case, Loper Bright or Raimondo, not many folks other than lawyers will see this as a significant case. Why? Because what it actually said was that under the Administrative Procedures Act, which is very important because it sort of governs all of what we do with the work of federal agencies, but it says that act requires courts, not agencies, requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to agency interpretation of the law simply because a statute is ambiguous. So you say, okay, fine, it's saying courts must do their job. Well, what it doesn't tell you is since 1984, there was a previous case, Chevron USA versus Natural Resources Defense Council, a case that produced something that we refer to in the law as Chevron deference, which is on questions of how regulations should be construed or understood, that the courts had been, from that case, actually directed to rely on agency interpretation in discerning how to give effect to what Congress' sort of statutory authority was that was passed to the agency. So it's basically saying that Congress and the agencies are the experts and the preferred voices on understanding how to take a statute, give it to an agency to have them make regulations, and then if there's any sort of misapprehension or misunderstanding about what it means, we start by listening to the agency. That created a significant reliance of both people who use agencies and people within agencies on how we understand what to do in any given situation when there were questions about regulations. And now what has happened is the court has significantly now opened up the world to challenge agency regulations, policies, and practices to private interest, business interest, whatever interest you want, individuals, mostly because what will happen now is instead of deferring to some agency understanding of the regulations, each court is going to be in a position to independently discern what should happen. What you will end up with is many different, depending on what court and what locality you are, interpretations, and no constancy. and the understanding in some ways of what the rules mean unless they get reconciled in appellate courts. The most important part of this is this rule has been in effect since 1984, right? And so what's been happening since 1984? People have been relying on the concept of agency or Chevron deference. Now it doesn't exist. So how it will actually play out, we do not know. We will figure it out as it goes along, but we know now that the apple cart is significantly or substantially upset. Okay, so since Dobbs, we've been expecting a series of cases continuing to push back against various types of state regulations on abortion, especially since in Dobbs the court said that the right to an abortion is not protected as a liberty interest under the 14th Amendment. But in the Mifepristone case, which might have gotten a very different answer if it was decided on the substance, what we actually got was one of the few unanimous decisions of the court written by Justice Kavanaugh. And the reason it was unanimous is because they did not actually answer the substantive question. The substantive question was whether the FDA's approval of Mifepristone was arbitrary and capricious. And what the court actually decided was the people who brought the case, this organization, a representation of doctors and others, they had no standing to raise the issue. Standing is a requirement that in order for you to file a claim in federal court under Article 3 of the Constitution, that you must be a party that has an injury, and for whom there is an ability, and it has to be a real injury, not something illusory, and that there is an ability for you to trace the source of that injury, and then for the court to hear a case that would redress the injury, right? So if you were injured, we can link the source or locate the source of the injury, and the court can redress the injury, then you have standing. But in this case, the court said we cannot identify monetary property or physical injury stemming from the FDA's actions of relaxing the regulation for the rollout of Mifepristone. And so the truth is the people who were bringing the claim were just the wrong people to bring it. Why? Because they had no skin in the game with regard to the use and the sale of Mifepristone. There were people who had moral objections to Mifepristone. They had some probably governmental objections to the FDA, but they weren't people who were truly affected by the approval. And so the sort of side note here that's a little interesting, so the court was willing to agree unanimously that these people were the wrong people and to punt this, meaning they're not going to hear the substance because they shouldn't have been able to bring it. But I want to draw your attention back to last term when we had Nebraska versus Biden, which was the case in which the president attempted to forgive the loan debt of students, and Missouri was suing, and the big argument from the government is Missouri doesn't have any right to sue because it has no standing in the loan case. And what the court actually says, well, Missouri proper doesn't, but they created this pseudo-governmental agency under the state that does some processing on the loans, and all that, although that body is not the state for this purpose, we will treat them as the same. And that's surprising because the real question is, did Missouri have an injury that was redressable and could be cited by the court? Actually, no, they didn't. Now, they could have punted it and they would have forced the sub-entity to come back and sue themselves, but they would still have to articulate their own injury. The point is, standing is one of those things where it's like pornography. The court knows it when it sees it. Of course they're standing for Missouri to sue on behalf of this sub-entity because we want to tell Joe Biden that he doesn't get to modify those loans. But when we don't want to wade any further into the abortion debate, we're more than happy to find that this doctors association is without the standing they need to make the claim. Okay, City of Grants Pass, another one I mentioned personal to me. It's personal to me also because the Ninth Circuit has been, so the Ninth Circuit, which California as a state belongs to the Ninth Circuit Court of Appeal in terms of our district courts feed their cases up to the Ninth Circuit. The Ninth Circuit has been particularly active in asking this question about what kind of rights do the unhoused have, and when is regulating homeless people regulating them based on their status rather than their conduct. So if you look back in the previous history, in 2019 and in 2006, in the Martin versus Boise and the Jones versus City of Los Angeles cases, those were cases where the cities basically criminalized sitting or standing on city streets. And LA was basically attempting to clear out Skid Row, so wouldn't let people sit or stand on the street from dusk till dawn. And then the question becomes, well, what happens to unhoused or homeless people during that time who have no place to go? And in the Ninth Circuit, what the Ninth Circuit Court of Appeals says, if you have people who have a status or are unhoused, who you know you have no place to go, and for which the city does not have a resource to ensure that they have some place to go, then when you criminalize the conduct of sitting or standing, when you know they have to sit or stand and don't have any place else to go, you have de facto criminalized the status, not just the conduct. So in other words, you've criminalized being homeless on Skid Row, you've criminalized being a person on the street in Boise. Those were pretty good decisions. I taught those decisions in my class as a reasonable sort of constitutional interpretation of the Eighth Amendment. Why? Because this is actually a cruel and unusual punishment case. It is cruel and unusual to create a statute that criminalizes sitting down when I have to sit down and don't have an option not to sit down. That's what the court said. So, your governor wasn't a particular fan of these laws, and he wanted to be able to have state and locality anti-camping ordinances, which would prevent people from sitting and sleeping on the street. So when it gets to the court, they start with a case that's helpful. Robinson versus California is the case that says you can't criminalize a status under the Eighth Amendment. That case said you can't criminalize the status of being a drug addict, right? So you can't say to somebody, we're going to punish you for being addicted to drugs as a crime. Great. But then they said, but that's not what's going on in these cases. They aren't criminalizing the status, they're criminalizing some conduct associated to the status, and they look to another case, Powell, and in the Powell case, what the court says, there was this case, Powell versus Texas, where we let somebody be punished for public drunkenness, where the defendant said, well, you can't punish me for that because I'm an alcoholic, and the only reason I was drunk in public is because my alcoholism led me there. And the court said, well, when you have a situation where you have some status or some malady, but there's a separate conduct that can offend the law, the fact that you have the status malady is not going to control. So you can be arrested for being drunk in public, even if it arose because you were somebody who had alcohol issues. The court applied that same principle here in Grants Pass. And so they separated the status of being unhoused or homeless from the conduct of camping or sitting or sleeping on the street. I struggle with this. I find that dissociation unhelpful and unrealistic. But I will say city regulators will say there are nuisance and pestilence and all kinds of things that have resulted from unhoused people camping wherever they want to. My sense is, well, then create some remedy that makes it so that they don't have to do that. My own city, I'm from San Diego, has had this problem. The mayor was actually waiting to see if an ordinance they had drafted was something they could now pass because they were waiting for the last term. But San Diego, as you might imagine, has a huge veterans population, and an unfortunately large number of them are homeless or unhoused. And so there will be a significant political pushback, I think, in San Diego. I think it's the wrong decision to separate the conduct and the status, but that's what happened. Okay, so finally, the little-known case that no one heard of that was decided along what we might think of as ideological grounds. Okay, so this case, the question is pretty easy. It's what, if any, type of immunity does a former president enjoy from criminal prosecution for actions that took place during their term? And what the court actually did is it created a three-tiered answer to it. So the first tier is for anything for which the president has conclusive and preclusive constitutional authority. That you can think about that as textually being committed to the president by the Constitution itself. If he enjoys that power, then in that space, the president has absolute immunity for conduct that takes place while they're in office that belongs to, we can call that Zone 1. But then they said, we can say there's this Zone 2 where he has at least presumptive immunity from prosecution for all official acts, and this is what they were clear to say, including acts at the outer perimeter of his official responsibility. It could be way at the end of his fingertips. And they gave pretty specific directions on how lower courts and charging officials are supposed to give significant deference to how they understand what's at the outer perimeter. And then finally, the president enjoys no immunity for unofficial acts. So this case actually in some ways just belongs to a trilogy of cases, two of which were already decided. So there's this previous case, Nixon versus Fitzgerald, where the court had previously decided in certain contexts that the president could not be sued civilly for official acts while they're in office. But many of you might remember the Clinton versus Jones case, where the court said, if the actions took place before you were president, Bill Clinton was accused to have sexually harassed Paula Jones prior to becoming president. The Supreme Court in 1997 said the president was not immune from civil liability in those cases, and they actually allowed the case to proceed. So to this, we add the answer of criminal prosecution and immunity. And again, now what we're going to have is we actually had the special prosecutor last week go back and refile the indictments, right? And what did they try to take out? They tried to take out anything that could be called, the official conduct of the president from the charging, to include directions he gave to members of his cabinet and the vice president, because as you'll recall, one of the charges was about directing the vice president not to certify the election results. Oh, no, anything you would say to your vice president, like if you told your vice president, go kill the homeless person down the street, don't, and that's the terrible thing. If you look at the dissents in this case, it's the parade of horribles of all the different things the president could do or say, which if you take the majority opinion to its logical extension, the president would be immune from criminal liability for. This, of course, also is thought to be, in some people's mind, I won't make the allegation, I will just raise the concern of others, that the court, in some ways, if you believe they were politically motivated, created a response that was sure to prevent the president actually from then being successfully indicted and tried before the end of this election cycle, right? Because based on this, you would have to have new charges, you'd have to go back for the new indictment, and then you have to come back now. And the district court is now going to have to, with each one of those new charges, ask whether, does it belong to something that's clusive and preclusive? Does it belong to the outer perimeter of what's official? Or is what he did unofficial? Because that's really the only place where you're going to be able to assert that there's criminal liability. Okay, so moving from the cases to my conversation quickly about what we think about the evolving Roberts Court. So last year I was here, and it was all about Alito and Thomas taking fancy trailers and plane rides and trips to Europe and elsewhere, backed by donors. And there was an outcry because what we learned was that the Supreme Court was actually not governed by an ethics code. The most concerned of the justice about this, because he's concerned about the appearance of it to the court, was Justice Roberts. So Justice Roberts announces to us in November of last year that the court has now promulgated its own code of conduct, and that if you looked at the code of conduct, you can pull it up online. It actually has guidance on regulations for outside influence and for when you should recuse, and what happens if they don't follow those sections? Well, I'm assuming Justice Roberts will talk very sternly to them. I am not pleased with that at all. Do better, because there's no teeth in it, right? There's no true punishment. It is a kind of a statement of what he believes their norms were all along, but it is not the same thing that we see elsewhere, right? Which is that for all other federal judges, there is a code of conduct that has not only the kind of guidance that the Supreme Court has, it has very strong prescriptions against doing anything that has even the appearance of impropriety, and it has teeth, including to what normally you might think of as potentially leading up to the worst type of thing that can happen to a federal judge, which would be impeachment, right? So the point is they still have set themselves apart. Has it assuaged the public outcry? I don't have any idea about it. I would suggest having some code of conduct is better than having nothing, but having a uniform code for all federal judges so that the Supreme Court justices aren't looked at as putting themselves above the law would be better. Okay, so what's going on in terms of, people talked about there were fissures on the court this year, and I think that's a gross overstatement of what's going on. So let's talk about what is solidifying. For better or worse, we do see what is the formation of a powerful dissenting voice in the three women on the court. And Justice Kagan, Sotomayor, and Jackson, they write some of the most, to me, emotionally reasonable and inviting dissents, where what they are trying to get the majority to do is to think about the people and how they really live and what this will really do, right? This is the tone oftentimes is, you do not have an understanding of the impact of what the decision is. And to me, the historical reference, it reminds me of the type of dissents we saw at the end of the Rehnquist court when Marshall and Brennan were often in dissent, sometimes with Stevens, where it's sort of, we are representing what we hope you will understand as to the people, the voice of the people who are absent from the court. The sad thing is, I think for the near term, they will be in dissent quite a bit, and it will be important for them to uphold making that record. I will say, however, that there is a solid 6-justice conservative majority, but you should not think about them as a monolith or as all being sort of equally committed to the same ideals. It is pretty clear that Alito and Justice Thomas actually might be singular. He might be an island all unto himself in terms of his commitments to things like the framers' intent and the kinds of historical limits he places on the power of the court. But he and Alito most often are together. But once you break away from those two, there's far more sort of issue-specific fissuring. Certainly, weirdly, and I never thought I would say this, Justice Roberts is what counts as a middle of the court right now. I mean, mostly because what sways Justice Roberts typically is upholding the legacy of the court, and there are times where he will vote, even as a conservative, for more measured decisions. You might recall that in Dobbs, he wanted to decide not to do away with the liberty protection for abortion, but he just wanted to decide that the state regulations were acceptable under the Constitution, and that way upholding states' rights, but not upsetting what had been the long tradition of recognizing the protection of the right. And so he finds himself in the middle for some things, but not others, like affirmative action. And then Justice Berkoni and Gorsuch and Kavanaugh, depending on the issue, they can be an outlier. But they all, in all the major cases, you know, we see 6-3, with maybe somebody splitting off just for one or more parts of the decision, but still agreeing in the overall decision. So it's pretty rock solid in terms of its power to affect law, but not with everybody agreeing on why some decision should work out some way. And so finally, the thing I want to talk to you, this is the kind of civics lesson part of this, is stare decisis, right? So stare decisis has been in the issue for the last 3 terms, mostly because there have been these complaints, largely in the media, that the Roberts Court has been disrespecting stare decisis. So these are 2 important related concepts in federal jurisprudence, one being precedent. Precedent is the simple principle that once we establish a rule in a case, in an earlier case, that it becomes authoritative to the court to govern other tribunals within the line of that court, right? So if the district court here or our Court of Appeal decides something, all of the district courts in the Ninth Circuit are going to use it as a precedent because the earlier rule shapes what happens next. Stare decisis is similar. It's that we stand by things decided. Once we decide things, we don't willy-nilly then decide them anew differently. We are governed by this concept that there is order to be gained from committing ourselves to the rules we made, sticking to them, and then having lower courts abide by them. That's the general principle, but it's not sacrosanct. Stare decisis is not an inexorable command, and it's actually at its weakest, we are told, when the justices are interpreting the Constitution, mostly because there can't be any prior commitment that limits whatever the current justices think about the duties on their current duties under the Constitution. And we might think about a perfect example of why that's a good thing to be the difference between Plessy versus Ferguson and Brown versus Board of Education, right? So when we look at Plessy in 1896, that's where we get the doctrine of separate but equal. So we had a state which created race-based accommodations on public transportation, and you had someone sue based on having to sit in the segregated seating. And what happened is the court said, well, having that segregated seating doesn't violate the Constitution because you could have a law that, as long as people all get to sit and have accommodations, that segregation or separation doesn't violate the 14th Amendment. But then we get, 58 years later in Brown versus Board of Education, where we're looking at segregation in the context of primary schooling and education. The court basically comes to the conclusion that the whole basis of the segregation is because of race, right? And so it has to be that the segregation itself is inherently unequal. What changed in that time between 1896 and 1994? The society changed, right? The understanding of what that segregation and separation meant changed. So the whole point is we cannot say that we expected the court to follow Plessy for the lifetime of the court, but the whole point should be it also shouldn't be willy-nilly overturning things. And the reason we've had these claims about the court being disrespectful to stare decisis or precedent, here are decisions from the last 3 terms that have either facially or de facto overturned cases. And so certainly we've overturned Roe explicitly in the Dobbs case. Grutter versus Bollinger and Fisher, which came after it, were effectively overturned by SFA versus Harvard. He didn't say these cases are overruled. He basically said the way these cases have used diversity, they can no longer do it. So what we used as the rationale for how race could be considered in college or higher education admissions has now been taken off the table. So without overruling it, he pretty much took away the teeth from it. And then this last term in Chevron was, in fact, on its face, overruled. Now, there is a rule to all this stuff, right? The court is supposed to go through this detailed 5-point reasoning when they do this, talk about the egregious error of the former rule, how it was poorly reasoned, how it was no longer workable, disrupted other areas of law. And here's the hard part. They're supposed to make a claim that there's no concrete reliance interest. That means people like you and me don't care about that law. You're like, I don't care about abortion. I'm not, I don't have any need for it. I clearly don't have a need for it, so I have no reliance interest, right? Or I don't care about agency action. The truth is reliance interest is about the broader community having confidence in the stability of the rule being the rule. And so the whole point is they haven't actually been really good with applying the rule. They did apply it in Dobbs. I think they had to because Justice Kagan was going to raise it in her dissent. In the other 2 cases, they didn't mention it at all in Harvard, and they did a very limited analysis in Raimondo, which they simply said, we think generally speaking, the important factors are here. That is a problem, and the reason it's a problem is this. Why do we care about stare decisis? It's the foundation of the rule of law. Trusting in I know you think, well, if I didn't like a law, I'm happy it's changed. That's actually not how it works. We have to have a foundational commitment that once things are decided, that we have faith and confidence that we can rely on those decisions and they're not going to be immediately turned around. And then the court also says it promotes the even-handed, predictable, and consistent development of legal principles and fosters reliance on judicial decisions. My favorite is the quote that they attribute to Brandeis. Respecting stare decisis means sticking to some wrong decisions. The doctrine rests on the idea, as Justice Brandeis famously wrote, that it is usually more important that the applicable rule of law be settled than that it be settled right. I know that doesn't sound right to you, but it is true, right? What we're talking about is reliance and predictability and understanding that when the court makes the determination, all the lawyers who then can read the opinion and say, okay, I know what to do, the lower courts know what to do. So people ask me, have they gone rogue, the Roberts Court? So I have some interesting news for you. I went and started looking at some resources, and here's what we actually find with them. If you look at the recent 3 years, the problem for the Roberts Court is they have taken aim at particularly vital, essential, long-standing precedents, but they have not overturned more cases than the courts before them. Actually, the New York Times did data analysis, and they found that the Roberts Court rate of overturning cases is 1.6 cases per term. That is lower than the Rehnquist, Berger, and Warren courts. So it's not that they're overturning too many cases. It's which cases are they overturning. The last 3 they overturned were precedents that were there for 40, 40, and 50 years. So the problem is not, oh, we're turning over every case. You're turning over the one we have the greatest amount of reliance interest in. Yeah. Okay, so let's talk about quickly so we can get to questions. I went through about 15 cases on the upcoming term. I picked the things that I think have general interest to the public or that I have knowledge of from my former life as a JAG or a federal attorney. And I think the ones that might have the most significant impact on families and communities. So the first I'm going to tell you about is United States versus Skermetti, which in 2023 you had Kentucky and Tennessee enact laws in this kind of culture war over what we do about transitioning children. They made rules on limiting gender-affirming care for transitioning children. And now what you have is the parents and doctors in those states suing to claim that those laws are violating the constitutional rights, likely of the parents and the children, to actually get the treatment they need for children who are experiencing gender dysmorphia. Right? So this is the next battle in the culture wars. If you think about affirmative action and abortion, this whole question over transitioning, what kind of care, what kind of rules states can place on this. So to me, this really should boil down to what are the rights to parents and physicians to make decisions for their children. But I thought that Dobbs would come down to what are the rights of women to make decisions about their body. So I could be completely wrong on this. So next we have Glossop versus Oklahoma. So, I follow capital punishment. I write about it. McCleskey is a low mark for me. This case is crazy town. So in Glossop, we have a capital punishment case where a man has been in jail for 26 years. And what we have is a lead witness has come forward and said they gave false testimony. And also what we have is multiple instances of prosecutorial misconduct. The prosecutor did things that were not allowed under the law in prosecuting the case. Here's the kicker. The state has backed away from defending the sentence. The state is not even saying they want, and still there's a question as to whether Glossop will be sentenced to death or not. So the question is whether Oklahoma can still execute Petitioner Glossop where even the state no longer defends the capital sentence. I don't understand. And I'm not making it, I don't understand. If justice means anything, it means the death penalty is the most severe penalty we hand out. We are different from most civilized nations in maintaining it. There should never be cases with errors that are this severe or egregious. To me, the default for him is not exoneration, right? The default to him is just a life sentence unless he gets a new trial or overturns it. But the fact that you would still consider carrying out the sentence, I don't get. So next, I'm doing this one because it relates to me, because this is about veterans claims and affair, and I got a bad knee, a bad back, and hearing that I know I'm going to need to file a claim for. And this is about what we do with veterans claims. So veterans claims are interesting, and because what happens, veterans have to go to the VA and file claims that they have service-related maladies or injuries, and there's this great rule that's called the benefit of the doubt rule. So if you're a veteran, how many of you veterans out there? Thank you for your service. I'm so happy to finally be able to say that. People say it to me all the time. So the beauty of it is if you come to a claim, you have some evidence that says, yeah, service-related, some that says maybe not. The statute says you have to be given the benefit of the doubt that your claim is service-related. And so that's a great thing. So there's this case where it went to the U.S. Court of Appeals for Veterans Claims, and it's not clear that the Veterans Court ensured that the plaintiffs or the claimants had been given the benefit of the doubt rule. And now the court has to decide, when you don't get the benefit of the doubt, does the Court of Veteran Claims have to ensure that you get it? And if they don't, does it have an impact on your claim? I hope the answer is yes. Like I said, my knee, my back, my hearing. Okay, and so the final one, this is going to be another gun case so soon. Garland versus Vanderstock deals with something I was just learning about when I left federal service that is very interesting, which is ATF attempting to regulate what we call ghost guns. Anybody ever heard of this phrase, ghost guns? I had not heard of it. So ghost guns are things that are not readily assembled already for the manufacturer, but for which you have pieces and assembly and you put together, so they're not coming with serial numbers and the whole business. But the whole point is the ATF actually didn't have any rules that covered ghost guns. And what happened is in their latest upgrade to their regulations, they just changed definitions so that they could capture people who were making ghost guns. And now you have people suing, saying it is beyond their statutory authority to change the rules to also regulate not only gun manufacturer guns, but ghost guns. So this is going to be interesting because this is going to involve the new Chevron deference, I would imagine, in some way, whether the court will defer to the ATF or whether the court is going to make up its own kind of ruling on what should happen when the problem for this, their original regulations didn't countenance that people would start putting guns together. All right, we're going to stop there so that people can come to the mic, but thank you.
Thank you. It was a great speech. I have a question for you. Put your fortune teller hat on, and what do you think is going to happen on September 18th with regarding Trump?
Every time I make a prediction about that, I am wrong. Because, can I be honest, it's sort of, it defies convention in so many ways, mostly because if I wrote a book about Donald Trump, the title would be Unprecedented, because so many of the things we are seeing are the first time they have ever happened within our long constitutional history. And so I always find I am doing nothing more than hazarding a guess, because it does not seem that what we know of the previous rules get applied in the ways we historically understand them to be applied. I found Trump versus US to be a sweeping, overbroad decision beyond what I could have possibly thought the court would have committed to. And I hope that's not about Donald Trump. I hope that's because those justices really believe that's the expanse of executive power. But I really don't think we have a reference to understand how normal historical processes related to executive power, regulation, criminal and civil adjudication will work for him, mostly because they don't seem to work how they have worked in the past. So I would just be guessing, and I would prefer not to, but I will be watching just like you.
Thank you.
I have a question about Supreme Court reform.
Okay.
One proposal that's gained some currency is 18-year term limits.
Sure.
My question is, do you support that idea? Do you think if Congress passed it, it would be constitutional? And in addition, what other ideas do you have for Supreme Court reform?
So my sense is you would do better. I mean, you would do better with a proposal that simply allowed you to add more justices. Mostly because it's absolutely lawful. There's nothing in the Constitution which sets our number of justices at 9. You certainly can add more. You could add 4 justices right now and pretty much upset what is the current conservative majority of the court without having to undertake, I think, the slightly thornier question of term limits, because then you will get the folks who will try to make the claim that the life appointment is something for which, if you are eliminating it, you could be violating constitutional protection. I think my co-author and friend Erwin Chemerinsky doesn't agree with that. He thinks there should be some ability to set limits on the tenure and to control the number of justices. I just think it is the less, it is the more dangerous way if you want a political fight over it. People might not like adding 4 justices. There's no way they could argue that adding 4 justices would be unconstitutional.
There are 3 cities in the state that are now deploying it to remove encampments.
Absolutely.
One of them is Long Beach.
Yep.
Another is Newport Beach. Long Beach has 3,000 encampments. What's a city to do if they face that situation? Close down a department so they have enough money to take care of the...
So I think I can tell you what the court said in Jones versus City of LA. What they said is if the city wants to enforce that kind of ordinance, then it has to create greater capacity in terms of the overnight beds it has. Because the problem in LA is they only had overnight beds for something like 40% of the city's homeless population. I don't think the answer is you have to be able to house every unhoused person, I do think you have to have the government benefit be at the level where we know there's not a situation where we have thousands of people who are going to be forced to be in violation of the law because they don't have anywhere else to go. But to your point, and I guess the answer is yes, am I saying if the cities become somewhat responsible for answering the call to find a solution? The cities are not separate from the larger community. We all are responsible for trying to find solutions that help us create, and all you have to create, you don't have to find permanent housing. The real requirement is for people to have places to sleep at night that are not on the street, even on a temporary basis. So if we could even increase, our resource for temporary nightly beds, that would lift the burden of limits on enforcement. At least that's what City of Jones said. The Supreme Court is fine with that enforcement. I'm just responding. I think cities have a responsibility to try to reduce the number of people on the street if they want to enforce regulations like that.
There was a kind of an unusual decision reached by either Cincinnati or Cleveland back in the 60s when I was going to school in the San Francisco area. And San Francisco had enabled a rule that said anybody who is homeless and hungry can come and we'll give you a check for $39 or $59. And so the city of Cleveland or Cincinnati bought airplane tickets for all the homeless in the city and shipped them to San Francisco.
Okay, so no offense, there's a local case where people were picking up homeless people in Orange County and dropping them off in Skid Row in LA. So there's a whole market in trading and transferring the unhoused. I will say this, I spent 3 years in Seattle, Washington, and one of the things they were doing when I left, there were a bunch of hotels and motels that actually closed down in COVID because of lack of use. The city was reverse condemning them and then using them as temporary housing for unhoused people. So I think there are a lot of initiatives, but the basic point is what do we do in a world where we know we have people who are living outside, but now we're sort of criminalizing standing and sleeping outside. There has to be some attempt at a policy solution.
So they were housing people in condemned buildings?
No, I'm sorry, no. Reverse condemnation is what the government does to make the private property public. So that yeah, think about it like public domain, or whether sorry.
Good question.
Yeah.
Thank you.
Where's Cynthia go? Where are you, Cynthia? Come on.
I have a question about gerrymandering. Why isn't gerrymandering for a partisan political end illegal? And if it's not, is gerrymandering ever illegal?
So the court's theory, and there have been a number of cases on this, is the whole point of political parties is to secure the end or success of their political party. There's nothing in the Constitution that prevents it, so it's not a protected status like race or gender. And the court says they mostly punt those cases and don't take them a lot because they say they don't have standards to determine when the actions of the party have gone beyond some level for which there should be some judicial intervention. So as long as you can say, this was squarely done for political gains for the party, the court says that is not something that is regulated under our equal protection. Thank you all very much.